total or partial stoppage of works by the workers for the purpose of convincing the employer to fulfill their demand. It's normally take place after the procedures that are stated in provision of Section 34 of the Labor Act when they are fulfilled. A lockout, it's a total or a partial stoppage by the employer, whereby employees are not permitted by the employer to enter the premises of the working place for the purpose of for employee to adhere or to meet the demands of the employer.
Okay, so it's like where each party has its own form. So lockout is for the employer, if I understand correctly, and strikes are for the employees. It's an action taken by the employees. Okay, Ms. Shuveni, we would like to find out, when can a strike or a lockout take place?
To look at the way when the strike takes place. The strike takes place in actual fact in the following way. It's when there is a dispute arise between the employer and employees, and they did not reach an agreement at their workplace. Then they refer a dispute at the Office of the Labor Commissioner, and that dispute has to be conciliated by a conciliator or an arbitrator, and it happened to reach a deadlock when these two parties did not agree to anything. Then it's when the strike, it's when the employees now do not agree with the employer on a matter of dispute of interest. For example, wage increment. Now, the arbitrator has to issue a certificate of unresolved dispute. Then from that stage, there will be a process of balloting, and in that process, employees have to show or to indicate or to state that they want to put more pressure on the employer to meet their demand. And if they vote, for example, in favor of the strike, then they come back to the Office of the Labor Commissioner. The strike rules has to be put in place by both parties. A notice has to be given to the employer within 48 hours. Then the strike has to take place.
So a strike has to take place within 48 hours after the strike rules have been set.
Sure.
Okay. I just wanted to make sure I understand the 48 hours correctly. So for example, if the balloting takes place on a Monday and a Tuesday, for example, the 48 hours only starts after the communication or the meeting has been had with all parties with the Labor Commission.
After the rules have been put in place, then the notice should be given to the employer.
Okay.
And it's after that, within 48 hours, the strike has to take place.
Okay, okay. Well, then we come to the next question, and we stay with Ms. Shuveni. Is there any prohibition to strikes and or lockouts?
Yes, there's a prohibition in terms of the strike. Let me just concentrate on the strike first.
Okay.
There is a prohibition on that. Meaning, employees cannot go on strike if procedures in terms of the Labor Act are not followed or are not complied with. Only if those procedures are exhausted by employees and employer, when the strike can take place.
Okay.
And as I mentioned previously, on the procedures, an arbitrator and a conciliator has to conciliate, an arbitrator has to issue a certificate of undisputed a certificate of unresolved dispute.
Yes, yes.
It's when now all the procedures has to be exhausted for the strike to take place.
Okay. Okay.
But on the other hand, a lockout, this is a pressure coming from the employer side, pressurizing also employees to understand their demand and to call them in order, and that is to not allow them to enter his or her workplace. Yes.
Okay. Before we continue with the conversation, I'd just like to inform our viewers that you're welcome to give us your comments so that you can be part of the conversation. You can do so through our social media platforms through which we are live streaming right now. We have our Facebook page, and that is at the Ministry of Information and Communication Technology. Ministry of Information and Communication Technology, Republic of Namibia. That is our handle on Facebook. You can also find us on our YouTube platform, and our handle on YouTube is MICT Namibia. MICT Namibia. That is on YouTube. You are very much welcome to drop your comments, questions in the comments section of those platforms. Coming back to the discussion at hand here, Ms. Nicanor, we would like to find out from you, what are the consequences of an employee going on strike or an employer ensuing a lockout?
The consequences of an employee, if he or she, the employees, if they go on strike, the strikes, there are two types of strikes, protected strike and unprotected strike. The consequences of in unprotected strike is that the employee might face a dismissal because that employee did not follow procedures as set out in Section 74 of the Labor Act, number 11 of 2007. And the other one for the protected strike is that the Labor Act, also Section 74, is stating that an employer is not obliged to pay an employee who is on strike for the services which are not rendered. So the principle of no work, no pay will be applied during the strike. So
pardon me, just for clarity, when an employee or the principle of no pay when you're on strike, sorry, we just need to get clarity on that. When is that then applied?
It's during a legal or protected strike when all the procedures are followed and the strike have started, officially started, and from day one, the employer is not obliged to pay the employees unless they agreed to pay each other, but the Labor Act is saying that they are not obliged. So the principle of no work, no pay will be applied. And the employee will not get a salary for those days or for months if the strike took more than a month.
Okay. Ms. Shuveni, when negotiating, what information should an employer disclose to the recognized trade union or workplace representative?
In the negotiation process, the employer is obliged to disclose all the information. Meaning, the employer must indicate or should indicate the information like how many employees are going to be retrenched, what categories of those employees, when is the retrenchment taking place, and when is this retrenchment take place, understand what is the reason for the employee retrench. See, these are part of the information that the employee need to disclose. Apart from the disclosure of information that is relevant for the employer to disclose, the employer must not also disclose the information if it is legally privileged, if it is prohibited by a court order, if it is prohibited by a court order,
Use that one.
if it is prohibited by a court order, or if that information is damaging or harm the employer's integrity. Yes.
Okay, okay. Mr. Sakaria, what is the difference between a protected and an unprotected strike and the consequences thereof?
A protected strike, when one is talking about protected strike, one is have to remember that there is a provisions in the Labor Act, Section 74 of the Labor Act, give guideline or give element to say for a strike to be called protected. So the requirements that are stated under Section 74 of the Labor Act should be followed. In a case to say the case have to be, or the issue have to be referred to the Labor Commissioner, Labor Commissioner to appoint conciliator, the dispute to be conciliated. If all those processes did not fulfilled, then certificate of unresolved dispute have to be issued, then strike rule have to be agreed. So when that is protected strike. So an unprotected strike is the strike that takes place without following the procedure or without any compliance to the provision of the aforementioned section.
Okay.
So the consequences of protected strike, when you are on the protected strike, as an employee, you are safe. Your work is guaranteed. Your conditions of employment is not changed. What is not there is no pay, no work, no pay. That's the principle. That's mentioned earlier on by my colleague. So the consequences of unprotected strike, that one, an employee who take place or who conducted or who find him or herself in an unprotected strike, that one is facing as consequences of losing his or her job. The issue of dismissal, the issue of discipline, in any case to say that is a major offense which leads to just dismissal.
Okay, okay. Ms. Josephine, we come back to definitions and clarity. What is picketing and when can it be done?
Picketing is a non-violent act on the side of the employees for the purpose of preventing employees who are not taking part in the strike to enter the workplace. That is picketing. And picketing is normally happening when there is a strike. Is when picketing taking place.
Okay.
Yes.
So picketing is usually an action by those employees that are striking to prevent others that are not willing to strike from entering the workplace.
Sure.
Is that correct?
Sure.
Okay.
Let
Okay.
me just come in there, just to add. Is it possible?
Yes, yes.
Okay. Other again is just to say, it's just to convey. The purpose for picketing was just to add what she said, is just to convey the message, to convince the non-striking workers to join them. Also just to convey the message to the employer.
Oh, okay. So it's basically trying to put extra pressure on that employer.
Exactly.
Ah, okay. As we said, it's a conversation, and you are very much welcome as our viewers to comment, to add your question if you have any that you would like us to pose to the panelists. And our social media platforms are open for you to do so. On Facebook, you can find us at the Ministry of Information and Communication Technology, Republic of Namibia. That is our Facebook page. And on YouTube, our handle there is MICT Namibia. MICT, Namibia. Our call-in lines are also there for you to do the same, and our number in the studio is 061 400 397. 061 is the area code, 400 397. While we wait for you to join the conversation, we then bring our next question to Ms. Nicanor. When can an employee who was participating in a strike or a lockout be expected to resume employment after that particular strike or lockout has ended?
Okay. After the strike has ended, all employees are expected to resume duty within 3 days, or when they became aware of that the strike came to an end, or when they reasonably would have become aware that the strike had ended.
Okay, okay. We also stay with you on this one because we also now want to find out, when will employees not have the right to participate in a strike or lockout?
Okay. The right to strike and lockout is not an absolute right. It's a relative right. So meaning that all the procedures must be followed before employees participate in a strike, and also before the employer lock out the employees. So the employees. Sorry, can you just repeat the question, please?
No, that's fine. Yeah. When will employees not have the right to participate in a strike or a lockout?
Okay. As I was saying, the right to strike is not an absolute right, but it's a relative right. The employees have to follow the procedures. So if the procedures are not followed, then they do not have the right to strike, or the employer will not have the right to go on lockout.
Okay. Yes, Mr. Zakaria, you wanted to add? Yes.
Okay, again, there are those services that are called essential service. So if the employees' work or activities are involved in essential service, so such an employees cannot participate or cannot take place or participate in the strike, because there's a provision in the Labor Act that say essential service. So if the service is declared as essential, then such employees has no rights to participate in strike or cannot go in strike due to the fact that the health and safety, let me say if an electrician went on strike, then in hospital or wherever, if people that are sick, then in ICU, then the electricity went off, now who should? So wherever there is health and safety and the life of people are at risk, then such worker could not go on strike.
Okay. Now, this brings me to my next question. A strike is usually one of employees trying to express their grievances and get employers, after negotiations, get to a loggerhead, if I can put it that way, get employers to see, their seriousness and put that pressure on. Now, if you have employees within these services that are aggrieved, how do they then go about dealing with it if it's not through a strike? What other avenues do they then get to use?
Okay, let me just say like this. The purpose for strike is to force the employer to agree or to adhere to the demands of the workers, because one can just go on strike on a dispute of interest. So that is the interest. Something that is not your right, to be part of your right, like something that is not on your contract of employment, on your policy, you want it to be part and parcel of your contract of employment. Then, if not agreed and case referred to the Labor Commission are still the same, then one cannot go on strike. To say now those ones that are part of essential service, their grievance, how to be the head. The channel for grievance are still there, but striking, they cannot go to on strike due to the reason I gave earlier on.
Okay. And then, yes, you can add?
If those people who are in essential services and they do not reach an agreement when they are negotiating, the only option is for them to go through to arbitration, so their case can be arbitrated. While on other services, the cases will just end up at conciliation, like to issue a certificate of unresolved dispute by the conciliator. But this one for essential services, let's say for the nurses, that one have to go through arbitration. After conciliation failed, then the conciliator have to refer the matter to arbitration, and then the decision will be taken by the arbitrator.
Okay, okay. Ms. Shuven, we would like to then also find out, a lockout is an action by an employer. Now, we have scenarios where, for example, if employees are striking, they can go through an action of picketing, for example, to block those that don't want to strike from entering. Now, if your roles are reversed and you've got employees that want to work, but there's a lockout, how is that then handled? What is the action that takes place there then?
Yeah. Can I just shift it to my colleagues?
Very well, Ms. Nicanor.
Let me come in. Before workers go on strike, there is what we call striking rules. They have to come up with striking rules with the assistance of the conciliator. So those rules, they should cover terms and conditions of their striking, because employees has no rights to block those ones that are not part and parcel of the strike. So the rules will say the distance when you are standing, when you are picketing, how many meters you keep away from the working premises, and any other condition to say if the nature call, the resting, all those things. So there is a rules to strike. Then those rules, they are there to be adhered to, because they give direction to say how one should go about, either the employer or the employee, those ones that are in strike.
Okay, so we can assume that the same then applies, or the same procedures then applies with a lockout by an employer. Can we assume that then?
Yes.
Okay. What right does an employee have then in a situation where an employer is having a lockout and they are being prohibited from entering the premises for them to carry out their duties?
I guess we do not have facts for that answer.
Okay.
We should have to put it on reserve, then we'll come back with a feedback.
That's fine. As we said, you can be part of this conversation. Our social media platforms are open for you to do so. Our call-in lines are also open for you to do the same. Our number here in the studio is 061 400 397. 061 400 397. You can find us on our Facebook platform, Ministry of Information and Communication Technologies, Republic of Namibia. Ministry of Information and Communication Technology, Republic of Namibia. That's our Facebook handle. On YouTube, our handle there is MICT Namibia. MICT Namibia. We continue while we wait for you to join us in this conversation. Mr. Nanjiwa, what is dismissal arising from collective termination or redundancy? In other words, retrenchment.
In terms of Section 34(1), dismissal arising from corrective termination is the reductions of the workforce or discontinuity of business operation by the employer for the reason of transfer or reorganization of of business for economic or technological reasons.
Okay. Simply put, what are the procedures to be followed by an employer in that regard then?
The same section I mentioned earlier on provides for the employer to inform labor commissioner and a trade union that is recognized as exclusive bargaining agent by the employer to inform them 4 weeks before the intended date of dismissal on the intended dismissal, the reduction of the workforce, the reason for the date of dismissal, and again, just to say the number and categories of employees that will be affected. So in case if there is no trade union that is recognized by the employer as exclusive bargaining agents, then employer should inform the workplace representatives in terms of Section 67 of the Labor Act, all the affected employee.
Okay. For clarity, there you spoke about an exclusive bargaining agent. What is an exclusive bargaining agent?
Exclusive bargaining agent is just a trade union that is recognized by the employer. That trade union should have majority of employees in that organization. Just to say, if a trade union is recognized by such an employer, that trade union has the rights to engage the employer on the basic condition, any condition that is affecting the employees, or to negotiate with the employers on the interest that we mentioned earlier on. Interests like salary increments or any other benefits that are not part and parcel of the corrective agreements of the or condition of employment or contract of employment of the employee.
Okay, okay. Ms. Shivani, you want to add anything to that?
I just want to end one point. That trade union should also be registered with the Office of the Labor Commissioner.
Okay.
And the certificate of registration has to be issued to that union so that it can now be have mandate to negotiate and have mandate to come to agreements with the specific employees and the employer in the specific industry or industries in order to represent them.
Okay, okay. Ms. Shivani, staying with you, can a retrenched employee refer a dispute of dismissal to the Labor Commission?
Yes.
Commissioner?
Yes, a retrenched employee can refer the dispute to the Office of the Labor Commissioner in the following sense. If the employee thought of or is of the view that procedures in respect of the Labor Act were not followed and the retrenchment was done not according to what should be done, that person is allowed to refer a dispute by law to the Office of the Labor Commissioner within 7 days from the date of the decision of retrenchment.
Okay.
Yeah.
Ms. Nicanor, what happens if parties during the negotiation did not reach an agreement?
Okay. If parties do not reach an agreement after the period of 4 weeks of negotiation, any party have the right to refer a dispute to the Labor Commissioner within 1 week's period after the negotiation ended, and the Labor Commissioner must appoint a conciliator to help or to assist the parties to resolve the dispute. And when the conciliator is appointed, a conciliator must convene meetings to try and resolve the dispute during the maximum of 4 weeks period. After the dispute is referred, from the date of the dispute was referred to the Labor Commissioner. And during that period, the employer must continue to negotiate in good faith, and the employer must not dismiss an employee unless the case is settled, and the employer must also continue to divulge all relevant information to the trade union which are relevant to the for the negotiation to for them to try and resolve the dispute.
Okay, but I stay with you now. For example, you spoke about the 4 weeks of negotiation, and that happens before the certificate of what is it called? Where the two parties unresolved. That happens. The negotiation happens before that certificate is issued, and now my question is
the certificate. Sorry,
no, it's fine.
the certificate of unresolved dispute is when there's a dispute of interest, when the parties they refer the dispute of interest to the Labour Commissioner before the strike. But this one is on retrenchment. So retrenchment, as my colleague have explained, is a dismissal. While strike is when they are in employment. So it's here there is no certificate of unresolved dispute at retrenchment. The 4 weeks which I have talked about is for negotiation, when they are negotiating, because they have to give the employer have to give a notice to the Labour Commissioner, as my colleague have said, a notice to the Labour Commissioner and to trade union before they retrench employees. Now those 4 weeks of negotiation, when one party is want to refer a dispute, then that party have to do it on the 5th week. So 4 weeks have passed of negotiation. 5th week they refer a dispute to the Labour Commissioner, and the conciliator will now have extra 4 weeks. Altogether, there are 9 weeks in order to resolve that matter.
Okay.
Yes.
Now this is what brings me to the question. After that time period has passed, the 9 weeks have passed, and the employer is still steadfast in their ways, what option does the retrenched employee then have?
As my colleague Ms. Shuveni have stated, the employee have the right to refer a dispute to the Labour Commissioner of unfair dismissal or failure to negotiate or to bargain in good faith, so that the Labour Commissioner can deal with it.
Okay, but for the interest of our viewers out there, can you give us hypothetical examples of some of those disputes and some outcomes thereof? Maybe Ms. Giovanni can also help you on that.
Yes, as she just alluded, that the dispute has to be referred to the Office of the Labour Commissioner in respect of procedures which were not followed or failure to bargain in good faith. The process has to start with conciliation, to see to it, in order to see to it whether both parties will be able to reach an amicable solution. And after the conciliation process failed, or parties, let me not say failed, but parties did not reach a consensus on that, then the dispute will be going to another stage, which is called arbitration, in which both parties now will state their side of their stories, and the arbitrator now will issue a document that is called an arbitration award in favor of what the arbitrator is of the opinion in terms of the law that it is the right. It is either now an arbitration award in favor of an employee or an arbitration award in favor of employers. It is a discretional issue by law, of which an arbitrator should have to come up with her own opinion in terms of the law, to see to it which party is likely to tell the truth in this matter, and the arbitration award should be in favor of that party.
Okay. Mr. Najiwa, we now take the same question, but we take it from the perspective or from the angle of a strike. With regards to retrenchment, it ends with the arbitrator, and that arbitrator's report based on the evidence that they have in front of them and what the law says. Now, with regards to a strike, you have a certificate that is issued, the balloting takes place, rules are set up, the strike takes place within 48 hours after the rules have been agreed to. What then happens in a situation where, for example, that strike takes, let's say, a month, and the employer is still not budging? What is the options of the two parties in such a scenario?
Okay. During the striking process, there is still room for these parties, the employer, the worker, and with the assistance of the conciliator to come together. So when they are striking, their representatives and the employer and the conciliator, they are still discussing, they are still engaging. Because remember, we said when striking, there is a rule, there's a principle which is called no work, no pay.
Yeah.
So this process, it's there in the law to make sure, to force either the worker, because the more you stay on strike, the more you do not get your pay.
Yeah.
Or the more the workers are not working, the more, or the damage the employer will have in terms of profit, in terms of food, or if it's a food, whatever economic, it's affected economical-wise. So that process, it make both parties to be forced to come together and to reach consensus. Otherwise, maybe if it's a dispute that's affecting, it's for national interest, also it goes up to the level of political, whereby the minister will be involved to see if the party will reach consensus. We have a strike of ShopRite, whereby it went on many days, and it reached that stage of taking to the stage of whereby the political is involved. So it's a process. It's even in the Labor Act.
Yeah. Okay. It's good to know that as much as, you know, there are these disputes and so on, at least we've got a strong legal board on which we bounce off to try and make sure that these things happen within the confines of our legal system. Ms. Nicanor, I go back to our topic of dismissal and retrenchment and so on. And here I would like to find out, what if reasons for dismissal are fallacious? What then happens?
Okay, if there is a disguise in the reasons of transfer or continuous of business operation, of the business which employs the employees who are to be dismissed or dismissed already, any party, the employees or their collective bargaining agent have the right to approach the labor court to apply for a relief of directing the restoration of the operation, or for reinstatement of employees, or for awards of loss of income.
Okay. Okay. Thank you very much for that. As we round off our program for this afternoon, just for clarity for our viewers to also go home with the various definitions and differentiations clearly. Can you then, Mr. Najihwa, or even Ms. Nicanor, differentiate between a dispute of right and a dispute of interest for us, please?
Okay, can I?
Yes, you can take it.
Yes, a dispute of right is actually in labor relations we have two types of disputes, which are dispute of right and the dispute of interest. A dispute of right is a dispute whereby the right of the employee is violated by the employer let's say, for example, if in the contract of employment, the employer have to pay the employee for services rendered, but at the end of the day, the employee is not paid. So the employee have the right to refer a matter to a dispute of right, which is non-payment, to the Labor Commissioner. And that dispute is referred to the Labor Commissioner in terms of Section 83 of the Labor Act. And the arbitrator, the arbitrator have to be appointed by the Labor Commissioner. And if that dispute is not resolved through conciliation, then the same arbitrator have to proceed with the matter to arbitration proceedings and then make a decision, as I have stated already, which is called arbitration award. Yeah, yeah. And from there, any party which is not happy with the decision or the award have the right to approach the labor court for appeal or for review. Then the dispute of interest is a dispute whereby, which is concerning any new proposal of conditions of employment. So the employees are trying to get new improvement or improvement on their condition of employment. It's not in their contract of employment. The example is like a salary increment. If they want to go for, they want their salaries to be increased, they have to refer a dispute of interest, which is have to be conciliated by a conciliator in terms of Section 83 of the Labor Act. I have to apologize. The dispute of right have to be referred to the Labor Commissioner in terms of Section 85 of the Labor Act. Okay. And the dispute of interest have to be referred to the Labor Commissioner in terms of Section 83, whereby the conciliator then try to see if the parties will reach an agreement. And if they don't reach an agreement, then the conciliator have to issue a certificate of unresolved dispute, whereby then they can go for industrial actions, which is strikes and lockouts.
Okay, okay. Very clear. Thank you very much. And at this point, we are rounding off our program for the afternoon, and I would like to ask our panelists if they have any last remarks that you'd like to add on. Starting with Ms. Shuven.
Yes, our final remarks to the public is the following. More especially in the labor market, we are here as the Ministry of Labor to inform you that in any event that is disturbing you at the workplace, before you take an action, you have the right to consult the Office of the Labor Commissioner and find out about the nature of your dispute and being assisted through the processes. And these processes are, as my colleague alluded earlier, these are conciliation, these are arbitration. From there, it's when, again, you can be assisted further should you not happy with the decision taken by arbitrator, which is called an arbitration award. And that award is a legal binding document. Until such a time, if a party is not satisfied, appeal against the arbitration award to the labor court. Okay. So you have this information that even if it is retrenchment, you cannot just sit home and say, I am retrenched and you are not happy. You still have the right to proceed, even if your employer has taken a decision without consulting the Office of the Labor Commissioner. You yourself, as an affected employee, have the right to consult and to come to the office for information purpose and for assistance.
Okay. Yes. Okay. Thank you very much. Ms. Mikano?
Yes, I just want to inform the public that the Office of the Labor Commissioner and or the Ministry of Labor, Industrial Relations and Employment Creation is for both employers and employees. So any party who feels that they need some information, they can approach us. It's not to say that it's only one part, we are there for the employees or we are there for the employers. We are there for employment, for the labor relations in Namibia. So they can feel free to consult us. We are in all regions, in all regions in the whole country. If the office, for example, Hobabis, there is no arbitrator, there is no one from the Labor Commissioner's office, they can still approach the labor inspectors because we are all from the same ministry. We are just a different directorate, but they will be able to assist them.
Okay.
Thank you.
Mr. Najwa?
Yeah, I just want to say collective termination or redundancy, which is called in a layman language retrenchment. It's a process that normally affects employees. So if it's not taken care of, so it will go to such a stage of even affecting the brain, because these people are people that were employed, have family to feed, where they were committed to their employment, have some commitments in terms of budgeting, in terms of properties. So I'm just encouraging both parties, or I'm just giving this information to both parties, workers and employer, to make sure the provisions of Section 34 in the Labor Act are fulfilled, for parties to engage one another thoroughly, at least to ease the pain. Thank you.
Thank you very much. With that said, we have come to the end of our show for this afternoon. We were looking at the topic, which at this point in time is one of great importance, that is strikes, lockouts, and retrenchments. From myself, Shianwa Desire Kahia, and my production crew, I would like to say thank you very much to the panelists who availed themselves to help us educate ourselves and our public out there. At this point, until Wednesday, bye-bye.